The appellate court on May the 21st, 2002, in Keller versus Keller, Anthony Keller in the trial court was ordered equal placement because the trial court interpreted what the legislation had in maximise as meaning equal placement. The appeal went there from his ex-wife to say, no, it doesn't mean equal placement. And in Keller versus Keller, the appellate court came down and said maximise does not mean equal placement. There is no presumption. The trial court has open discretion to make whatever he wants to do. 2002. February the 3rd, 2004, Loftus versus Loftus. Paul Loftus went to court. He changed his lifestyle around to see his kids. He bought a house closer. He got a better job. He did everything he possibly could to make substantial change of circumstances to spend more time with his children. The trial court said, no, you haven't met the burden of substantial change of circumstances. So Paul took it to the appellate court, and the appellate court upheld the trial court, which basically gave the trial court open discretion in deciding whether what was substantial change of circumstances, and if he didn't like it, you didn't get it. Now, I would hope that coming 12,000 miles to parent my child would deem me as a substantial change of circumstances, but who knows. On April the 6th, 2004, Arnold versus Arnold, still in the appellate court. Dave Arnold had a constitutional challenge to use what I've spoken to you about with the US Supreme Court rulings to take to the appellate court and say, no, this isn't right. This isn't right. The state cannot usurp my parental rights to liberty, interest in the happiness of parenting my child. And that was, and the original decision by the trial court was upheld, and the burden that Arnold was trying to get to wasn't met. So basically, the states, the appellate court said what it is stands. So except just every second weekend and one night through the week. On March the 14th, 2006, on Bourne Prathseth versus Lewis, it was a standard trial court where Dave Lewis received 28%. I think that's a 10-4 split. Dave Lewis took it to the appellate court and said that's not right. David Lewis is a state-sanctioned foster carer of kids between 2 and 4. The state pay him money to care for other people's children 100% of the time. Yet the court deemed that he was only good enough 28% of the time to care for his own child, who was 3 at the time, the same age. June 2006, Mike Landwehr versus Landwehr, Supreme Court, all the way to the top. The court shall set a placement schedule that allows the child to have regular occurring, meaningful periods of physical placement with each parent, and that maximizes the amount of time the child may spend with each parent. In the Supreme Court case in 2006, this is a father who loved his children and wanted to be fully involved in their lives up to 50%. The trial court said, no, you stay at every second weekend and one night through the week. The appellate court upheld the trial. And when it got to the Supreme Court took statutory construction and it said the court shall set a placement schedule that has allowed the child to have regular occurring meaningful periods of physical placement with each parent. Every second weekend and one night through the week does that. So the court was allowed to make that ruling. And then it said maximizes the amount of time the child may spend with the parent. So therefore, after you've got your placement set, then you have to maximize the time you spend with your child, which basically said he shouldn't go golfing Sunday morning when it's his weekend. The Supreme Court pretty clearly told the legislature in that session that it didn't understand what maximize meant. It didn't understand how to interpret the legislation that's out there, and that it had no choice but to uphold the trial courts every second weekend and one night through the week. If you read the Supreme Court case, the court actually gave the legislator instructions that it could not interpret the meaning of the current laws and that they needed to be simplified and made clearer. I believe the Supreme Court wants this bill, and I believe it needs this bill to help align itself with the most recent 2000 and 2005 Supreme Court rulings. I do not find it surprising that the divorce industry professionals you've had testify simply forgot to fill you in these appellate and Supreme Court rulings, and that even though these cases have set case law in stone over the last 6 years, They still want you to believe that the 2000 laws need time to flow through and settle in. You've all heard these industry professionals tell you that they would not recommend equal placement if there is conflict. The reason industry professionals are involved in your case is because there's conflict. The court does not assign guardian ad litems or send you to psychologists unless there is conflict. Of course, the breakup of a husband and wife, or mother and father, is an emotional time. After all, the definition of divorce is, I don't like you anymore. I don't want you in my life. We need laws that calm down the emotions, not inflame them. We don't need industry professionals that will recommend a known unequal outcome which ultimately rewards the parent that is causing the trouble. I'm going to rebut some issues that I've heard in testimony about this bill.
Peter, I just want to make sure we stay on track because I want to make sure we have time to ask questions. I know the committee is going to have some, so if you can somehow condense and tie it up, that'd be helpful.
Well, I can leave the. Well, I'll okay, that's fine. I'll race through some of these. Attorneys are skilled professionals. They know that parents will give their hearts and soul in their bank accounts to maintain their relationship with their genetically bonded own flesh and blood. They know this and use it to win a case for their client. The breakdown of a husband and wife relationship is an emotional time, but over time it will level out. There is nothing more damaging to a father or mother to lose your children in an adversarial process. There is nothing more certain that tempers will flare and conflict will occur when that happens. If you take away the win component, you will take away the conflict, and that is truly in the best interest of the children. Equal parenting will guarantee the child-parent relationship will remain intact and all the conflict will dissipate. The emotions will calm down and parents will get on with their lives and get on with parenting their children. I've heard the divorce industry professionals tell us the sky will fall. On the contrary, the sun will come out. Our children will smile as dads participate in their lives. Our children will start to heal the wounds created by the conflicts of unequal parenting. We will have less teenage pregnancies, less truancy, less youth suicide, less drugs and alcohol abuse. We will have happy children. The status quo that exists currently is failing. That's why this committee is here. To perpetuate status quo is failing in this committee's charter. The floodgates. I hear that, well, don't change it because the floodgates will happen. Well, that's not a bad thing that dads are flooding into their children's life. In my opinion, that's a good thing. And we shouldn't let last year's bad decisions stop this year's good decisions simply because we have to work a bit harder to make right what is wrong. Contact and child support are linked whether statutes state or not. I've heard testimony that say that they're not linked, they're individual. Well, I can tell you if dad's not paying his child support, when dad goes to pick up his kids from mum will phone the police and get him for child support. I've heard you say I've heard testimony we don't want to make laws for 2% of cases, but we already do make laws for murderers and we make laws for driving correctly. Those that settle or stipulate are guided by Supreme Court and Appellate Court laws, and the standard cookie cutter every second weekend and one night through the week is what we have had since Kramer versus Kramer. These laws have settled in. There is no more evolution or getting used to them. Supreme Court decisions and Appellate Court decisions since 2000 have set all case law into the future. What you have now is written in stone. We're sitting here today because we need to strengthen Wisconsin families. We're sitting here today because our communities are suffering. The most importantly, our children are suffering. We're sitting here today because we all know there is a bias in the family courts. A bias that, on purpose, produces a cookie cutter every second weekend and one night through the week for dad. My father taught me a simple lesson. There is right and there is wrong. And what is wrong needs to be made right. This bill is about our children. This bill is about the Boston tea tax. It's about the suffragettes. It's about sitting in the back of the bus. This bill is about our children's expectation of equality in the workplace, and to fulfill their expectations, we need to teach equality in the home place. It's about treating and teaching our children with fairness, equality, and respect. This bill is not about me. I am already 12,000 miles from home. I am fathering my child. This bill is about you and whether you as a committee members have the integrity and the honour to honour the child-father relationship as much as the child-mother relationship. This bill is about integrity. If you believe in money and that the divorce industry is the right place for children to be, then vote no for this bill. If you believe that time and that the nurturing of a child by both parents is right, then vote yes for this bill. Thank you.